Iku Iluna, please rise.
Aohea o ko e ko ka aha, inahe kuliana I mua o kea aha ho o kolo kolo ki e hana hano o ko moko aina o Hawaii. E naoi mai, e malio mai, I lohe ia ka leo. Hear ye, hear ye, hear ye. All persons having any business before this Honorable Supreme Court, State of Hawaii, draw nigh. Give your attention and you shall be heard. E noho I lalo. Please be seated.
Please call the case.
Case number SCWC-20-0000172. Carrie N. Noborikawa, petitioner, claimant, appellant, versus Host International, Inc., respondent, employer, appellee, and Ace Insurance Co., adjusted by Corvell Corporation, respondent, insurance carrier, appellee. Arguing for petitioner Carrie N. Noborikawa, Wayne Mukaida. Arguing for respondents Host International, Inc. and Ace Insurance Co., Jacqueline Amai. Argument on the merits.
All right, good morning. Aloha, everyone. Our proceeding today is being broadcast live on Judiciary's YouTube channel as well as on Olelo. Counsel, are you both ready to proceed? All right. Okay, we've allocated 30 minutes for each side. Mr. Mukaida, you've asked for us to give you warning when you're 20 minutes into your initial argument, so you can reserve 10 minutes for rebuttal. Ms. Amai, you'll have 30 minutes, and we'll give you a 10-minute warning as well. All right, please proceed, Mr. Mukaida.
May it please the court, I'm Wayne Mukaida. I represent Ms. Noborikawa, who injured her knees at work. And because of her knee injuries, she could not do her job and she was terminated. I've been trying to figure out how the Labor Appeals Board arrived at its decision. So in doing that, I examined the term percentages. It's important because that term is used differently in two sort of separate but related galaxies. The first galaxy is the American Medical Association Guides to the Evaluation of Permanent Impairment, the fourth edition. And the second galaxy is, of course, Chapter 386. Ms. Noborikawa's knees were rated under the AMA guides. She was rated at 5% for the right leg and 0% for the left leg. And what the Labor Appeals Board basically did was add 3% to each of those ratings for permanent partial disability of 8% and 3%. Now, the AMA guides follows the whole man concept. And percentages under the whole man concept, if there is more than one body part that's injured, the sum of all the percentages for the body parts cannot exceed 100% or the whole man. So as an example, if a person lost an entire arm, would be 100% arm impairment, but a 60% whole man impairment. And similarly for a leg, 100% leg impairment would be a 40% whole man impairment. And to combine these different percentages so that they do not exceed 100%, you go to the back of the AMA guides and you take the larger percentage first and go down to that value and then sidewards for the second percentage, and then you come out at a total number which is less than the sum of the two separate body part percentages. So we have a range of percentages from 0 to 100%, of course. And what do these represent? the MA guides say that at the bottom end of the range, a 0% rating is assigned where there are no functional consequences to the employee. At the opposite end of the range, and maybe I'll quote this, quote, a 90 to 100% whole person impairment indicates a very severe organ or body system impairment requiring the individual to be fully dependent on others for self-care, approaching death, end quote. So with an MA rating percentage, a percentage nearing 100% whole man is assigned only where death is imminent.
Mr. Mukida, could you focus in on the facts here and where you think the majority went wrong? In other words, you were arguing for, I believe it was 20% on the right knee, if I'm correct.
Yes.
And I'm on the left knee, I think it was a higher percentage than they came up with, which was 0 and for the director and then 3. What's your critique of how did the board go wrong? In other words, I don't think they were anywhere close to the upper end of the range that you're talking about. So where do they go wrong here on these facts?
And that's precisely the point that I don't understand. I was trying to figure out why the LAB, the Labor Appeals Board, felt constrained to keep its percentage low, its add-on percentage of 3%. In a case where a person has lost her job, this court in the Ihara case suggested that a person's inability to do her work is precisely the kinds of impairment that PPD was meant to address. So while 3% may be on the low end, I think where a person loses her job, that would indicate a fairly high impairment.
How is the board supposed to, where does it come up with numbers? I mean, is it, they look at other decisions, they just kind of eyeball it? Where do you come up with, 3%, 8%, 20%? Where does that, where should that come from, I guess is the proper question.
I guess initially when somebody takes a look at the AMA guides, there are lots of fancy charts and numbers and percentages, and it all looks sort of scientific, but actually it's not. A bunch of physicians get together and they review numbers and they put the AMA guides together. And I think it's important to understand that, as stated in the very beginning section of the AMA guides, in fact, I think it's at page 17, one of the principal goals of AMA guides was to achieve consistency between ratings. So there's not a lot of fine tuning involved. And as an example, to rate a lower back impairment, the principal method for rating that is to assign the injury into one of 5 categories. Category 1 is at 0%. Category 2 is between 5 and 7%. There's no 8 or 9%. Category 3 is between 10 and 15%. Then there's a break, there's no 16 through 19%. And the next category is 20%. So there are those breaks between those ratings because I think one of the goals of AMA guides was to achieve consistency between ratings. Now,
and I think this sort of touches on what the Chief Justice just asked you, but, LIRAB basically said you presented no evidence to support your 20% and 7% impairment ratings, and that was on FOF 19. And I understand what you're saying. She was 100% disabled from her former job. She has the daily, life impacts. But I'm just wondering how that translates to 20%, 7%, and how you would explain your quantum of PPD. And also this is, you make the argument that there wasn't enough for LIRAB to sort of track their decision. So I'm wondering what facts they would need to have to support your PPD rating.
Yes, and to address that, and also the Chief Justice's question, taking a step back, broadly speaking, I think the way that the evidence should be considered by LIRAB is the same way a jury, pardon me, in a personal injury case should consider all the evidence. You take all the evidence, throw it into a pot, mush it around, examine it, and you come up with a verdict. That's the same way a PPD percentage should be arrived at. I would submit that in reading LIRAB's decision, that basically the LIRAB ignored IHARA. It repudiated IHARA.
Ihara, you mean? I'm sorry.
The IHARA versus DNLRA case, it's a decision of this court.
Ihara, the Ihara case, right?
Yes.
Yeah, okay, I'm sorry.
In its decision, in its analysis and discussion section, the LIRAB reviewed Ms. Noborikawa's argument that PPD should be considered in light of the claimant's inability to do her job as a restaurant manager. And immediately following that, the LIRAB said that that argument was, quote, without merit. But this inability to do a job is precisely what PPD was meant to cover. In essence,
But in the findings, didn't they say that they considered the impact at home and as well as work? So it seems like they did consider it.
actually, that was, I think, in a summary section. The findings were very, very limited, the specific findings of fact. And I would suggest that without a clear understanding of what the IHARA decision required, that LIRAB basically didn't know what facts to look for.
They're supposed to
and-
look at the impact the injury has in the claimant's ability to continue doing their work, right? The impact at the workplace, the work environment,
Exactly, but
because that's part of your daily activities, is it not?
that's correct.
But they seem to acknowledge that they did look at that.
They gave, I think, lip service to that because, and I say that because immediately after stating that claimant's argument had no merit, LIRAB said that the argument ignored the fact that the claimant also has vocational rehab benefits and temporary total disability benefits.
No,
But-
I understand and I appreciate your argument on that. I know what point you're making with that, but let me ask you on the flip side, you could also be asked, how did you come up with 20%? What is that based on? Is that
And-
5 plus 15 or how is that number calculated?
And
And why not
I-
25? Why not 21? What about 17?
I will get to that. But I want to emphasize that voc rehab and TDD have absolutely nothing to do with PPD. I think this is a clear illustration of how LIRAB completely missed the point and missed the law. And again, just to follow up on voc
Yeah,
rehab.
those are different compensations
Exactly.
that relate to the injury, but it's not compensating for the injury itself, right? That's PPD.
That's correct. And the fundamental distinction that was noted in IHARA is that things like voc rehab and TDD are sort of indemnity payments, whereas PPD is an award or compensation for loss of use or function. So they're totally separate compensations, and all of those compensations can be awarded in one case. And in fact, the statute states that a person's ability to work again does not reduce PPD.
Mr. Makeda, so going to this idea, right, that so if LIRAB majority didn't give enough merit to the fact that your client could not continue on with her prior job, and so is your argument that once you accept that fact, that you get 20%? How does it, I think that we've been trying to get at, how do you get to the number?
Again, I think, I'm sorry, my answer stays the same. There is no magic way to arrive at a number. We have to consider all the facts and come up with a number. One way to do it, I think, would be to try and examine what the range is of PPD that can be awarded. And
You're looking at the comparable, the statute at all in terms of what comparable injuries are set forth in the
there's
statute?
nothing in the statute. It
It's in
just
the AMA,
suggests
right?
that if less than a whole leg is lost, then you take a percentage of it.
Have you ever seen a case where you have the rating given by the doctor and the add-ons or residuals, whatever, however you call it, was higher than that rating that's been awarded by the DCD or the board?
I do not recall that.
Do not recall seeing that?
I never saw a case like that.
Is it always
And
less?
no, but I would suggest this.
Can you answer my question? Is it always less than the rating or equal to? The rating given
My
by the
experience
doctor.
is that the AMA rating is always less than the PPD award. And as a
Well,
footnote,
that doesn't make sense. You got 8 here and the rating was 5.
I'm sorry.
I don't think it makes sense on what you just said.
I might have misspoken. The rating is always lower than the PPD.
This case was unusual because it was higher. I'm trying to, they
I
ended up
think-
awarding 8% and the doctor's eval was 5. Is that an unusual set of facts?
I'm sorry, I didn't catch the question.
I think that doctor's evaluation was 5
Yes,
and LIRAB came back,
added 3% for a total of 8.
and is that unusual?
No.
That's
In fact, that points to the very problem with LIRAB's procedure. It's almost, I hesitate to use the suggestion, but it's almost automatic that LIRAB almost formulaically adds 3, 5, 7% to an AMA rating. And that is precisely what
Regardless of the facts of the case? Is that what you're suggesting?
regardless of whether or not a person was able to continue his or her job. I think that's correct. And I think opposing counsel would agree with that. And I think, with all due respect, Justice, that might have been your experience in private practice, that these add-ons were always relatively small percentages.
Well, that's why I'm asking you, have you ever seen a case where you had the doctor's rating, in this case it was 5 for the right knee, and the add-ons were at least 5 or greater? Have you ever seen a case like that?
The add-ons were 3%.
Yeah, have you ever seen it greater than the doctor's rating? So here the rating was 5%?
Oh, you mean like greater than a 5% add-on?
Yeah, so the add-on was 5 or 6 or 7, but greater than the rating given by the doctor. Have you ever seen a?
No, I have not, and I don't know where such a standard or limitation would come from.
Is there some sort of presumption under the law that the AMA ratings are presumptively valid and therefore LIRAB is supposed to start with that as a base?
There is no such presumption, but the statute suggests the use of various guides, such as the AMA guides. But I would also point out that the AMA guides, with its goal of achieving consistency, what that means is that with a particular injury, that sets a floor for what that injury is worth, because it considers the person's inability to do certain functions, like a range of motion. That's one of the main characteristics or the main diagnosis. That's common to everybody with that injury. So in Ms. Noborikawa's case, the 5% right knee impairment rating provided a floor for everybody with a similar knee injury.
So, but the law does require an individualized assessment depending on the facts of that person's circumstances.
Exactly.
And does the law say that you're supposed to look at the impairment not just as to how it might affect that person's work performance, but their daily life activities?
Yes, the AMA guide specifically refer to ADLs, activities of daily living. Then the Ihara case suggests that you look at other factors where the AMA impairment rating might not be a full representation of the limitation, and that you can take a look at, like we're talking about, the inability to do the particular job she was working at. And
It's kind of unusual for women to be able to leg press 235 pounds, is it not?
she went to the gym because she knew her job was very physical, and in fact, she injured her knees lifting a 125-pound beer keg. But let me also point out this to show what the range involved is. If we had a secretary with the same knee injury, she could probably return to work with little or no loss of function. So in a case like that, a 5% AMA impairment rating plus 8%, plus 3%. Let me back up. So for the secretary with little loss of function, the AMA rating plus 1% or 6% might be fair because she can return to work and do all her duties. But in Ms. Noborikawa's case, the Labor Appeals Board awarded her 8%. So what was supposed to be stuck in between 6 and 8% or 7%? And let me suggest these as examples. That in that small gap, you might have an employee with occasional light pain, with occasional moderate pain, with frequent moderate pain that lasts maybe 5 minutes, an hour, or all day. The employee might have flares of pain, which precludes standing for an hour. The employee might be restricted from squatting and kneeling, bending, climbing, twisting, turning, bending, crouching, and so forth. The employee might have limits on standing more than 6 hours, or 5 hours, or 3 hours.
Counsel, can I just ask you, and I apologize for interrupting, on this 8% that was awarded by the board for the right knee, how did that break down? You said it was an add-on of 3, but that's not really what the decision says. It just says 8. In my reading of the decision, I can't tell if that 5 from Dr. Langworthy was adopted in whole or if it was partialed out. Maybe they only took 4 of that and added 4 on. Can you determine that?
That is certainly a possibility, but
You're assuming it was 3.
I have to back up a bit. And because in the Ihara decision, the court used the term impairment and disability as being synonymous. I think that was correct because that is the way the terms are defined in 386.1. So impairment equals disability. And I think we have to be careful in our discussions on PPD to make a distinction between an AMA rating and an AMA impairment and PPD under 386.
Mr. Mukaida, do you think the dissent got it right in its approach? I'm looking at the concurring and dissenting opinion, which has a little more, at least has more detail in its analysis. It talks about, looking at VR records, says Dr. Chong needs to be considered carefully, number of surgeries, where she was placed, and then unable to work in 6 of 8 FCE work categories. So there's certainly a higher level of detail. Is that a minimum level that you think we should be requiring of the majority at that level? And more generally, do you think the dissent's approach was the correct one analytically?
Yes, I do. I think that Chairperson Vasconcelos got it right. Chairperson Vasconcelos was a longtime claimant's attorney. I think he considered factors that the Ihara case suggested should be considered. And the chairperson basically adopted my argument at that time and awarded the 20% that I had argued for, and a little less. That's on the right side. And for the left side, he awarded a little less.
It seems like our discussion so far it was just sort of circling around, where are they coming up with these percentages? How are they doing these percentages? But one of your main arguments, as I saw it, was to figure that out, LIRAB needs to sort of explain things and how they got there. Isn't that sort of the crux of this case?
Exactly. Under Kauai Springs, it was required to sort of give a breadcrumb trail so that we can understand how it got to its conclusion. But I think the Labor Appeals Board was not able to even consider what facts it had to look at. It did not make any findings regarding the details of what she was not able to do at her job. They just dismissed that argument that should be considered. They
I don't
totally
know if I
missed the
agree
boat
with
on
that. I'm sorry. I'm not sure I agree with that. They said they credited her testimony as it related to her daily activities at home and at work.
I think that was lip service, that none of that was
It's a
stated.
finding of fact.
I might be mistaken, but I believe it was before the findings of fact that was stated, sort of in
I'm
a
looking
summary.
at the findings of fact,
All right, then I stand
It's both.
corrected.
5 and 6.
They credited her inability to do her activities of daily living, but it did not specifically examine what she could and could not do at work.
Well, so
Taking-
is your argument that you're looking for the kind of detail that the dissent provided in that opinion, that would make it sufficient to figure out how these numbers were arrived at? Is that where you're going?
Yes, we need that kind of detail, but I would also point out at least 4 examples of where you might get to a more mathematical approach. Ms. Noborikawa was required to work 10-hour shifts. She was required, 80% of that time, she was required to be on her feet. She was not able to do that. Did that represent an 80% disability? Number 2, we talked about Chairman Vasconcelos looking at the functional capacity exam, which is a very detailed and long physical therapy exam. And he pointed out that claimant was precluded from 6 of 8 work categories. Did that represent a 75% loss? Ihara suggests that a loss in earnings capacity can be considered not as a wage replacement benefit, but sort of as a corresponding indication of a loss of function. So Ms. Noborikawa had been earning $61,000 to $65,000 a year. That comes out roughly to $31 an hour. After vocational rehabilitation as a medical coder, she earned about $16 an hour. So did that represent an approximately 50% loss of function? And in fact, it was worse because she was limited to part-time work at 6 hours a day. And as we previously covered, Ms. Noborikawa was able to leg press 200 pounds before injury, but now she's limited to 37 pounds. Was that an 82% loss? LIRAB did not address any of this. And as you pointed out, LIRAB did not explain how the losses of function were limited to 3% above the ratings.
Mr. Mukai, I have a question. For this record, there's one doctor who has provided the AMA ratings, right? Dr. Langworthy. Isn't that unusual? I mean, typically in workers' comp cases, and I don't know if specifically in PPD type situations, but usually there's a multitude of different expert opinions. Why isn't there another approach or another opinion here? And should that matter?
Yes, this is not in the record, but my experience is that it's relatively common to just have one rating exam done. There are sometimes more examinations having to do with other issues such as compensability or the precise
But
nature
her
of the treatment.
treating physician, Dr. Blaine Chung, also gave a rating, right?
Not a specific percentage rating, as I recall.
Would you be capable of? I mean, is there specific expertise you need to provide a rating for PPD? Treating
You need, I
physicians,
think, at least some understanding of the AMA guides would be helpful.
but treating physicians certainly are able to.
And the guides specifically allow an attending physician to provide a rating.
You would hope, in fact, that they would be able to. I mean, they should know the claimant better than anybody, you'd think.
Yes, but I guess the attending physician might feel a bit conflicted perhaps if he provides a rating which is his patient might think is too low. So I think there's some reluctance to that. Also, it takes a fair amount of time.
Mr. Mukaida, we're up to about 28 and a half minutes. And
Thank you.
if you'd like to reserve some time for rebuttal, perhaps wrap up now and we can move on to Ms.
I was going through examples of what limitations might be fitted into a 7% rating, that gap between 6 and 8. And after all various limitations, there might be limited hours that a person could work, and then you arrive near the top at a total inability to do work. And how can that 1% spread, that 7%, represent PPD ranging from a minimal loss of function to the other extreme of a total inability to do a job? I would submit that it can't be done. And certainly LIRAB did not provide a means for this court or anyone to understand how it reached its decision. Thank you. I'll reserve my last 30 seconds.
All right. Thank you, Mr. Mukaida. Ms. Amai.
Good morning, Chief Justice Rechtenwald and Associate Justices. My name is Jacqueline Amai, and I'm here representing the respondent's employer and insurance carrier. Regarding the issues raised by claimant in her application for the writ of certiorari, employer and insurance carrier submit that the appeals board did state with specificity the reasons supporting its award of permanent partial disability benefits. And it was enough that it enabled the reviewing court, here the Intermediate Court of Appeals, to track how it reached this determination. For claimant's second issue, we submit that the Labor Appeals Board did not disregard this court's ruling in the Ihara decision, and rather specifically embraced it in its decision and order. Throughout these proceedings, since the Ihara decision was issued, which I will note, it was interesting timing because we had gone to hearing, I believe, on October 18, 2017, and that was actually, I believe, 5 days after perhaps that the Ihara decision was issued. I apologize. The DCD hearing was on October 18, 2017. The Ihara decision was issued on October 13, 2017, and the decision and order, the supplemental decision and order by the director, was issued on December 13, 2017. At the time of the hearing in October 2017, which again was right after the Ihara decision was issued, claimant argued for 8% PPD of the right knee and 2% PPD of the left knee. And as indicated in the director's supplemental decision and order, which ultimately awarded 7% PPD of the right knee and 0% PPD of the left knee, it is documented that claimant relied on Dr. Langworthy's July 30, 2010 independent medical evaluation and permanent impairment rating, and the testimony that she has pain and difficulty with housework, climbing stairs, kneeling to clean the tub, and rising from the floor.
Can I ask you, what's your response to Mr. Mukaida's argument that it's unfair for the claimant here to receive the same kind of PPD award as someone who had a relatively sedentary job and suffered the same injuries? So and this is addressed in the majority's opinion, referring to a secretary who might have suffered the same injuries, have the same symptoms, but because that person is able to return to their usual and customary job, that's one set of facts. Here, this person isn't, and his argument is that's unfair, and the board's answer is claimant's argument is without merit. Why is it without merit?
I agree with the appeals board in that when you read or go through claimant's pleadings, she always raises that issue, and I believe it was raised here today, where they give the example of a secretary and a pinky injury, a secretary versus a pianist. And I disagree in that it doesn't mean just because the pianist, we all think, uses the fingers to play the piano, perhaps as a job, that that's any more disabling or that would equal a total disability over a secretary. Claimant's scenario or hypothetical presumes the fact that the secretary is going back to work just because it's
Wait, but doesn't
presumed
that go
that
to
she
the degree
doesn't.
of impact?
I beg your pardon?
Doesn't that go to the degree of impact on someone's job, which is their daily activity? We spend more time at work than we do at home. And why doesn't that go to the degree of impact on the work activity, which is part of someone's daily activity?
I'm sorry, Justice Stevens, what was the question?
Aren't we really talking about the daily impact or the impact on someone's daily activities? Why doesn't that matter, the degree? So that if you have a secretary that can go back to work, keeps his or her job versus someone who lost their job completely, isn't that a difference in the impact that injury has had on their job,
Yes,
their
it
daily
is.
activity? And shouldn't there be a recognition of that difference?
Yes, it is, Your Honor, and I would submit that the appeals board did recognize that here.
Well, they said it's without merit, that argument.
I believe that it's without merit in terms of how claimant presented that
They
argument.
were presenting that argument in the context of PPD. And then the board shifted to TTD and VR benefits, which are completely different benefits. We can agree on that, right? Can we agree on that?
I agree. I would
So,
submit that the
so my
appeals.
question is, how do you reconcile that? You know, what the board says in the decision versus your argument?
I would submit that I believe, or I would just submit, I don't know really what the board was actually thinking, but I can understand its rationale in that it was without merit, in that the hypothetical just, again, presumes facts that we don't know about the secretary, and I don't believe that in saying it was without merit is that the board was not saying we do not look at whether the impact.
But the facts are clear. It says same injury, same residual symptoms, able to return to her usual and customary sedentary job, while this individual can't. That's the hypothetical, and the board says that's without merit. And then the board goes on to explain, I'm quoting, one cannot look only at the PPD award and conclude that the injured employee was or was not unfairly compensated for his or her injury. What does that mean, that sentence?
I believe that the board is suggesting or stating that whether or not a claimant can do his or her original job is not the only factor, but one factor to consider in permanent partial disability determination. And actually, our position is that that correlates with what this court stated in the Ihara decision, that looking at a pre-injury job and whether or not the claimant post-injury can do that same usual and customary job is one factor. It's not a mandatory factor, it's a discretionary factor. It may be considered, and it's not the only factor considered.
But in determining the PPD, that has nothing to do with VR benefits or TTD, right?
Correct. I agree.
But that doesn't seem to be what that statement is, what the Chief Justice just read. It seems to be that the board is saying, well, you also have to look at these other benefits they receive. But the hypothetical that I thought claimant's counsel was posing had to do only with the calculation of PPD.
I understand, Justice. I don't know how we would reconcile it in that I'm just suggesting, just from what I'm reading in the context of the board's decision, it was just one factor. And
I understand. Thank you.
So as noted, the Ihara decision has played a big part in claimants' arguments throughout this claim. And I will note, as we've discussed already, that even as stated in the introduction of the Ihara decision, regarding the second issue addressed was whether a PPD determination may be based upon a claimant's post-injury inability or reduced ability to perform the usual and customary work activities in the position claimant occupied prior to the injury. And the
Counsel,
court
I'm
explained.
sorry, Counsel, on that point you're raising, it seemed to, it wasn't clear to me from the board's decision, but it seemed that they took Langworthy's 5%, Dr. Langworthy's 5%, and added 3% onto that. Is that how you read it?
Actually,
They come up with the
Justice,
8?
the director ordered 7, so the
No, I'm
board.
talking about the board.
Correct. So in looking at the 7, I believe the board actually just ordered 1 more percent because employer carrier paid the PPD award. And so going up, I understand it's de novo.
Okay, but at the end, it was a 3% add-on to the 5% for the right knee.
Yes,
Okay, and they also gave 3% on the left knee.
yes.
Okay, but there seemed to be a consensus that the right knee was much more impaired or disabled than the left knee. And I think everybody seemed to be on the same page, including the claimant who said that the right knee was at a 25% function level and the left knee was at a 40 to 50%, yet the residuals or add-ons were the same. How do we make sense of that?
All I can say, Justice Devins, is that regarding the court's discussion with counsel earlier about, and I believe you also asked the question, have we ever as practitioners or even case handlers seen a decision or an award by either the board or even the director that exceeded, in terms of the residual subjectives, additional PPD amount, whether they exceeded the actual rating? And I too will agree with Mr. Mukaida that in the cases I have handled, I have not seen that. And I will not say that it's an automatic ceiling that the director or the board imposes, but I do have to say that I have never seen, in my experience, a decision where the board, ordered or the director ordered an amount that exceeded the rating. And I do
Just to
want
be
to
clear,
note,
that'd be 10% in this case, right?
I beg your
That
pardon?
would be 10%. In other words, you've never seen, if this case the rating is 5, you've never seen a case in which the director would have ordered more than 10.
Correct.
Okay, I just wanted to be sure. Thank you.
Yes.
Is there some sort of like repository of information as to what type of, PPD percentages have been awarded here in similar situations?
I am not aware of it, Justice McKenna. I believe that the repository would be the decisions, and in fact, the decisions by the director, which would be more abundant than that of the board or even this court, it's not public knowledge. So you'd have to have either been involved in the case or have the decision because your client has it. But if you as
Are those decisions considered confidential because they relate to injuries? I'm wondering, why is there not access to those decisions?
I believe it's just, even though it's so-called public records, we have been told that because it involves a claimant's medical records and information of a very sensitive nature, only the parties are allowed. And even within that confines, the employer carrier would still need to get authorization from the claimant in certain circumstances to even access or request records from the claim file in which they are parties.
How about
So-
one? Sorry, go ahead.
So, like, for example, employees counsel or employers counsel do not cite to other similar cases because those cases would be considered confidential, basically.
Correct. In that, if I were to use a decision that I know about, then definitely I'm redacting any kind of identifying information, and you're just kind of submitting it to, at the first level, the Disability Comp Division as as
Persuasive
value.
authority.
Yes.
Okay, thank you.
Yes.
What about LIRAB? Are those decisions available publicly?
Okay, that is public.
Okay.
We can get that on Lexis, and it is published, and so that is accessible.
So why not require reference to other decisions that show in particular circumstances what the additional percentage were so that at least we have something to go on in terms of measuring whether it's reasonable or not?
That is often what is done in hearings where permanent partial disability is an issue, but given that the determination is so fact-specific and individualized, you would have to, at least when we have done it on behalf of the employer carrier, really make sure that the extent of facts or the medical scenario, even the diagnoses are the same, because it can easily be argued, well, that's not the right, that's not the same leg, that's not the same rating, that's not the same measurements, range
Sure,
of
it's always
motion.
going to be distinguishable, but at least it's something. Because, you know, frankly, after listening to the argument today, it's really pretty rough justice. You know, the board's sort of like, well, okay, 3%. Mr. Makaida's like, you know, an additional, I guess, 15%. And, you know, kind of like, okay, how do we know that one is right and one isn't? And I asked him, what about the dissent? I mean, it's a dissent. What's wrong about the dissent's approach? It has at least a higher level of detail than the majority, it would seem. Why not require the same level of detail from the majority in this case or other cases?
I acknowledge that that is an option, but I do want to also submit that with regard to the dissent, Chairman Vasconcellos also did not explain where did the 20% come from? Where did the 5% come from? Because he actually had a different position on PPD that should be awarded for the left knee. So yes, his was more detailed. I would also submit that Chairman Vasconcellos was also looking at the same body of evidence that the majority looked at. The testimony by the claimant at the time of the trial, all the medical reports, that was all in the record. So all of the facts that Chairman Vasconcellos referred to in the dissent was before the majority as well. They
But
just didn't
his
detail it.
add-ons at least reflect the difference in the severity of the right knee and the left knee, whereas the board, they're at even 3 and 3. And I'm still trying to make sense of that when all the evidence points to the right knee being much, much worse than the left knee and having a greater impact in her activities. Yet the rating comes out even. You have any comment to that?
I think that's just the board's discretion, Justice Devens. I will note
But it goes
that
against the great weight of all the evidence. The evidence is uncontroverted that the right is much more severe. She said 25% versus 40 to 50 on the left.
the evidence also, as noted by Justice Ginoza, doesn't contain any other impairment rating. And I will note to clarify that in the workers' compensation proceedings, there should, or is almost required, although it's not stated in the statute, but by practice, by the Disability Compensation Division, that the impairment rating be done by an agreed-upon physician. And so even if parties come in with their own rating, it's not necessarily going to be credited because an argument that would be credited is by the claimant. We didn't agree to that rating. And similarly, the employer carrier could argue, we didn't agree to that physician. And so there is this requirement that it be agreed upon. And in
But a
this case,
zero
just
rating,
one.
a zero rating doesn't necessarily mean you're not impaired or disabled, right?
I beg your pardon,
A
sir?
zero rating does not mean you're not necessarily disabled or impaired.
Correct,
You could still be functionally impaired, correct?
correct.
Thank you.
Yes.
You know,
No, you go ahead, go ahead.
so Dr. Langworthy was the agreed upon rater in this.
Yes, he was.
And, you know, something you said earlier, I just wanted to make sure I understood this. I think you started your argument by saying claimant relied on Dr. Langworthy's opinions before the director, and in fact argued for 8% for the right knee and 3% for the left knee, which is a little different than what Dr. Langworthy said, but based off of, I guess, what his opinion was. Was that a factor in what LIRAB majority did here? I didn't see anything about that in the decision, but if claimant changed her positions fairly drastically to argue 8% before the director and 20% before LIRAB, I'm just wondering, I just wondering what impact that might have had.
I believe that because they're de novo proceedings before the board, my recollection of the proceedings before the board, they did not question at the time of trial the reason for claimant's change. And
Okay.
I believe it was just the whole de novo nature, so
Okay,
there was no questioning.
thank you.
Dr. Langworthy seems to have based his PPD on just a range of motion analysis. And I'm wondering, do the AMA guidelines allow for different sorts of criteria other than range of motion to determine the level of impairment or disability of, say, for example, a knee?
For the knee, no. For example, the spine, there are diagnosis-related estimates. For the knee, it's mostly, I believe, just range of motion.
Why is that if the knee cannot sustain, for example, no longer sustain a 235-pound leg press?
I do not know, Justice McKenna. I mean, the AMA
But that
guides
doesn't
have
really
that.
seem to make sense because the knee function isn't just the range of motion. It's what you can do, squats. And this person apparently
There
can't
are
squat and things like that. And it's the physical activities are severely limited now in terms of what she can do.
regarding the chapter dealing with the lower extremity. In addition to range of motion, there are other elements such as atrophy or nerve damage or other medical-based factors that the rating physician can look at, and then
And weight, bearing of weight is not one of them?
I don't believe so. I don't believe so that they would measure that, from what I'm understanding.
And how it affects somebody's ability to do daily activities of physical activities. That's not considered,
Not under the AMA guides.
even though disability is defined to include loss or impairment of a physical function. It's not just the function includes many things other than range of motion, right?
Correct.
This isn't making a lot of sense to me.
I will also note too that under the statutes, the AMA guides are one source that the director or even the board can consider, and they can look at other kind of orthopedic studies and I think the key, it doesn't say this, but I think the understanding would be it has to be an accepted publication or something that the medical community does look at, but relying on the AMA guides is not mandatory. They could just completely disregard it and use another factor or not any at all. But I believe, as our point is here, it has to be substantiated, right, what their finding is. And so employer is submitting that even claimant's 20% is not substantiated by the evidence. I mean, how was it determined?
Well, that's exactly right. I mean, it seems, it's what we've been talking about all morning, the magnitude of the impairment rating, it just seems so loosey-goosey. I mean, you had Dr. Langworthy at 0% for the left knee, 5% for the right knee. Then the DCD keeps it at 0 on the left, bumps it 2% to 7%. Then LIRAB comes in, jacks up the left knee, which was the better knee, 3%. The right knee goes up 1% to 8%. I mean, how are we, this court, supposed to know what factors really went into that calculation?
I understand, Justice Edens, and I believe that the answer would just be what's been discussed here is that the level of specificity required by any fact finder, and this would even include the director.
Okay, and it seems that those findings, it really wasn't findings. It seemed like the majority was simply just cataloging what they reviewed. Doesn't there need to be some further explanation with regard to the information that they reviewed and how it impacts the impairment rating?
Arguably, yes, I agree. You could, but yet at the same time, the Intermediate Court of Appeals was able to track it, and they listed, as we've noted in our papers, but I do want to point out that the board's findings of fact in its decision in order. Claimant was unable to return to her usual and customary job as a restaurant and bar manager as a result of her work injury to both knees. That was findings of fact 1. Number 5, claimant's testimony was credited regarding her recurrent symptoms in the right knee. Similarly, findings of fact number 6, claimant's testimony was credited regarding symptoms in her left knee. So they did specify the factors that they looked
But
at.
is it tethered to the actual impairment ratings? It's not.
Ms. Imai, do you have, I'm sorry, do you have any concerns, or what is your response to Mr. Makaita's kind of listing of approaches to categorize functionality to assist in setting a more deliberate way of setting the numbers? What's your response to his listing of those categories? You know, the number of hours per day somebody can work in it, because first of all, she went back to work for a little while, right? And then
Yes.
and then terminated. So I mean, there's a lot of different ways, I guess, of categorizing those types of things. But what's your response generally to his argument?
I think it's a valid consideration, but if that is going to be imposed, I would submit that it should be imposed across the board in terms of it applies to all PBD determinations, or both the director or the board must specify more factors in how it's calculated, or actually show the calculation on what is the impairment rating based on, so that everybody can see the factors. And I think that it has to be broad enough yet specific enough where it can apply to all of those. And maybe that's an impossible thing, but it can start. But it has to be able to be, I think, reviewed, duplicated, used by the public. And we have to remember too that we have a lot of pro se claimants in this area. And so it needs to be, I think, explained enough in whether it's case law or even statute that's changed, such that a broad range of applicants and practitioners and users of this system can understand it. And I believe even the physicians, because you can always then, I can envision you provide statute to the rating physician and say, we need you to address these factors. And I will say that's what we do nowadays too, in terms of any kind of decision, whether it's by the board, this court, the Intermediate Court of Appeals. If there are things that affect their rating, such as disability and the definition of it, as really emphasized in Ihara, at least for our clients, we're providing it to the independent medical evaluating physician in our questions, so that they understand what context that they're rating in.
So I'm just curious, where does the board never awards more than the rating amount for an additional amount? In other words, 5%, board never goes higher than 10. Where does that come from? Like, written down anywhere, statute, regulation? That's just the way life is?
And I don't mean to be so cavalier, Chief Justice, but I think that's how the practice is, in that it's one of these, as we refer to, unwritten rules of the Department of Labor. It's just, it just is. And so actually, if you track what kind of claims people make, especially with attorneys, there is going to be a certain range of what they ask for in residual factors. And oftentimes it doesn't exceed what the rating is. And so whether that's right or wrong, that's just what has manifested from practice, from decisions, from how both the director awards PPD as well as PPD, what we settle for when we just negotiate settlement. And the settlements are reviewed by both the board and the director, depending at what level you're at. So
Well, why wouldn't it all make a lot more sense if the board simply said, historically, this board never awards more than the same amount, never does more than doubling the rating for the following reasons, and then cite a case. And then we could look at this and go, oh, okay, so maybe that's a good reason, maybe it's not. Assuming we think it's a good reason, then we sort of look at what happened here, and I guess we can kind of ballpark 0 to 5 and think, well, she kind of got 3, that's pretty good, all things considered, so good outcome, but we're not able to do that. with the decision that's here. That's the problem. I think that is a problem. And the other thing I wanted to point out, coming back to Justice Devons's question, I'd asked you, what does it mean that, when the board says in rejecting the argument that it's unfair to treat this individual the same as a secretary who suffered the same injury, says one cannot look only at the PPD award and conclude that the injured employee was or was not unfairly compensated for his or her injury. I think that's the lead-in, as I read it now, the lead-in to the next paragraph, where basically they're saying, hey, you know what? She did really good. She did fine on the VR and TTD, so no reason to go crazy on this one. That's sort of how it reads. Is that an accurate statement of the law? It's not an accurate statement of the law. There's nothing in the law that says the amount of vocational rehab and TTD benefits should have any impact on PPD, right?
Correct. There's nothing in the law that states that. And I believe that even in Ihara, the distinction was made between the type of benefit a VR-related temporary total disability benefit would be versus a permanent partial disability, wage loss versus loss of function.
Very well. Anything, we have a little bit more time if you want to wrap up. Any further thoughts for the court? And I don't mean to rush you. If there's anything you want to
No, just at the end that we're submitting and requesting affirmation of the Intermediate Court of Appeals summary disposition order. Thank you.
Very well. Thank you for your argument. Okay, Mr. Mukaida, a brief rebuttal. And I'll give you a little more time than the 24 seconds you currently have. Time, but not too much, okay? We have another argument coming up.
There are so many points to cover, and I'll try my best. First of all, there are questions about activities of daily living. The AMA guides specifically include ADLs within a rating in order to be considered. What definitely is not considered is what a specific job requires. Those are expressly outside of the AMA because each job has so many different requirements, and a physician would not know about that. We've also been using language such as, quote, add-ons, end quote, or, quote, subjectives, end quote. And I would point out that the Ihara case, I think, requires us to use a different vocabulary. There's no difference in private practice. The term impairment and disability, those two terms were words of art. Impairment meant AMA impairment, and disability meant PPD. But under Ihara, they're synonymous. So I think our language has to be a little bit more careful. And I suggest the term AMA impairment when referring to a rating. Justice McKenna was looking for some sort of precedent. We're looking for some sort of standard. And there was also a question about whether data is available. Unfortunately, there is not. The state was required to publish a data book every year, and it was done until a few years ago. I pointed that out in my brief. The data book had a lot more of a breakdown, but the most it did was total the number of PPD cases. There was not a breakdown with respect to ratings and so-called additional add-ons. And unfortunately, the most data that's published now is in the annual report for the entire department. And all that does, there's way less data. It just reports the total number of work comp cases.
Mr. Mukaida, if you could wrap up, we're about more than 2 minutes over your allotted time. So if you could wrap up with any final critical points.
The questions suggested that LIRAB cases might serve as precedent in some sort of standard for PPD. I suggest that that is not appropriate. As a reminder, we're dealing with administrative law, if there's something that's supposed to affect cases broadly, LIRAB has to go through rulemaking procedure, and it has not done that. Ms. Amai, there was a question about what standards Langworthy used to measure a leg. The AMA guides provide, in fact, 13 different methods for evaluating a leg. And all Langworthy did was take the diagnosis and plug it into a chart and came up with 5%. It's a small detail, but even Langworthy in his report referred to the wrong chart. He referred to a chart for the ankle and actually should have been the next chart over for a knee.
Anything further, Mr.
Thank you very much.
All right. Thank you to both our counsel for your arguments today. The court will take this matter under advisement.
E ku iluna, please rise. Ua ho'o malolo ia mai ne ke a aha ho'o kolo kolo ki e ke hana hano. This honorable Supreme Court is now recessed.